Hi, everyone, and welcome. We have over 300 people joining our call today. Very, very strong turnout, and it just shows us how serious everyone's taking this upcoming FinCEN rule. Staying informed on changes like this puts you, as the real estate agent, in a better position to support your clients and protect your business. So thank you for taking the time to be here today. I'm Christy Marino, sales manager here at WFG, and I just want to thank you for being here and also introduce our amazing Washington sales team. These are the reps that service you and your brokerages every day. And after today's session, they'll be following up with a recording of today's class, a question and answer guide based off of the questions you put in today's chat, and any additional support you might need as we move towards the March 1st go live date. We are very, very fortunate to be joined by Teresa Williamson, who's been leading WFG's national FinCEN training effort. She's here to make sure you know exactly what to expect and how to prepare. Teresa brings over 30 years of experience in title and escrow, is licensed in 21 states, and currently serves as WFG's Senior Vice President of Compliance and National Training. She's trained teams across the country and has a real talent for turning complex topics like FinCEN into practical guidance. Before we delve in, just a quick reminder, because we have so many people on the call today, drop any of your questions in the chat thread throughout the session, and if we don't get to them live, we'll include your questions in the follow-up guide. With that, please join me in welcoming Teresa Williamson.
Good afternoon, everybody. Thank you for joining. I am having some technical difficulties, Christy. My screen share that you can see seems to be stuck. I think we sat it there so long it just got comfortable.
We started about an hour early. If you want to, if you want
Yeah.
to send it my way, I'm happy to scroll through the deck for you, Teresa.
I'm going to just stop sharing it for just a moment and try and share it again. Let's see if I can get it here, you guys. Okay, I think I'm in business.
CK just mentioned, Teresa, if you mute your computer, it might help.
Okay. All right. Well, thank you everybody for joining us this afternoon, taking time out of your schedule to learn about FinCEN's new rule. It's going to affect all of us in ways that we hadn't imagined. You'll have a lot of questions, and we at WFG can be a resource for you. Please don't hesitate to reach out to one of your reps with any questions you might have about this rule. Money laundering is the process of disguising illegally obtained.
Teresa, it's Christy. Sorry to stop you, but it seems that we're having a little bit of an echo. Can you put your mic on mute real quick and then unmute it?
Okay, is there an echo now?
That's perfect. That's perfect. Thanks, Teresa.
Thank you. Okay, super. So money laundering is the process of disguising illegally obtained financial assets from illicit activities such as corruption, embezzlement, and drug trafficking into funds that appear legitimate, allowing those funds to be used without detection of the illegal activity that they came from. The act of laundering money includes 3 stages: placement, layering, and integration. The placement stage introduces the illegally obtained funds into the financial system or legitimate commerce. The layering stage separates the money from the source by funneling it through multiple financial transactions in an effort to create confusion and distance those funds from its original criminal origin. The stage The integration stage reintroduces that money into the economy by making it appear that the funds came from a legitimate source. This is typically done by combining the illegally obtained funds with legally obtained funds or assets and providing a credible source for those funds. Anti-money laundering laws and regulations are intended to make it difficult to use the funds obtained from illicit activities. However, anti-money laundering laws and regulations generally target financial institutions and regulated industries, such as ours, that move money, leaving the real estate sector vulnerable. So what are some common schemes to launder real estate launder money in real estate? Well, purchasing properties with cash where there's no institutional financing, meaning a cash conveyance of ownership under this rule means that it includes hard money loans, seller financing, third-party loans, contracts for deeds, no exchange for funds, and Bitcoin. Purchasing properties with cash, you avoid financial institutions that have anti-money laundering practices in place. And therefore, the financial institutions, if they're bypassed, the risk of money laundering increases as there's no safeguards in place to report suspicious activity. Conspiring with others in the purchase, conspiring with other parties. Besides the seller and the purchaser, or the transferee and the transferor of property, real estate players include attorneys, real estate agents, investment advisors, and financial institution employees. These real estate professionals can be involved in the money laundering scheme by turning a blind eye or by willful participation. They can assist in hiding the source of funds for a real estate purchase by manipulating the price, bypassing requirements, or adjusting information for the benefit of the money launderer. They add a layer of distance between the money launderer and the real estate transaction. Purchasing properties through shell companies. And that's really what this new real estate reporting law is focusing at, is these shell entities. A shell company is a front business that lacks active operations and significant assets. As shell companies are legal entities, they conduct business through their name, hiding the true identity of the individual behind it. Purchasing a property with a shell company masks the true buyer and the origin of the funds, thus adding distance between the illegal funds and the purchased asset. And renovating or flipping properties, the money laundering through renovating a property involves paying cash to vendors for property improvements. The cash is accepted by the vendor for legitimate services, and the source of funds not typically scrutinized as they flow through a legitimate business. The capital improvements to the property paid for with illegal funds increase the value of the property. So these are some ways that money laundering is occurring. Between 2016 and 2023, the number of employee hours dedicated to complying with financial regulations and examiner mandates increased by 61%. In 2024, global money laundering estimated between $2.22 trillion and $5.54 trillion. And according to Smart Search, a company responsible for creating one of the very first electronic anti-money laundering services back in the early 2000s, reports that the United States had the highest number of anti-money laundering events per capita, almost 3.5 events per 100,000 people. And that tops the list of the 20 worst offending countries for anti-money laundering events per capita, followed by the UK, United Arab Emirates, Australia, and Canada. FinCEN uses this data to detect and prevent money laundering, support law enforcement, and protect national security. The data that is collected through this FinCEN reporting of residential real estate transactions is private data. It is not public data, though the FBI and the CIA, financial crimes enforcement units, have access to it. And they will tie those spaghetti strings together to identify their targets. There are some severe penalties for non-compliance. Negligent violations, civil penalty of not more than $13.94 for each violation, and an additional civil penalty of up to $108,489 for a pattern of negligent activity. Willful violations, not to exceed $278,937 per transaction if they determine through an exam that the participation was willful. And criminal can include a criminal fine, a prison time. So it could be up to 250,000 or prison time or both. What you need to know is that the Department of Treasury's Financial Crimes Enforcement Network has implemented an anti-money laundering regulation that affects real estate professionals. It targets residential real estate transfers, and on a nationwide basis, certain persons involved in those real estate closings and settlements are to report information to FinCEN about the specific transfer of residential real estate. The rule went into effect on December 1st, 2025, and they put a delay on the requirement to report until March 1st, giving us an additional 90 days to prepare. Residential real estate transactions are reportable when the following criteria is met: that the property is residential real estate, that it's non-financed, and that at least one of the buyers is a legal entity or a trust. I'll describe residential real estate on the next slide, and provide details about the definition of cash under the rule. And remember that this applies only when the purchaser, the grantee, is an entity or a trust. Individuals would be exempt. Residential real estate is defined in the rule as 1 to 4 family dwellings, townhouses, condos, and co-ops. It includes improved acreage upon which 1 to 4 family dwellings sit. It includes improved commercial tracts, which contain 1 to 4 family dwellings. And you think, well, what? Consider the high-rise downtown, the Hilton or the Marriott. But at the very top, there might be 2 or 4 penthouses, residential penthouses where people live. If a commercial structure, if a commercial property has any residential unit within it, it now becomes reportable under FinCEN. Multi-purpose property, if it's a hardware store downstairs and there's 1 or 2 apartments upstairs, that's mixed use. That includes residential property. It is reportable. Unimproved lands, which the transferee intends to build. So if it's a 1,000-acre tract and a developer is going to subdivide this 1,000-acre tract, it's intended for residential purchase, that 1,000-acre vacant land tract is reportable. And this includes property in the United States, Puerto Rico. It includes Indian lands. What transactions are covered? cash purchases, accommodation recordings, trustees' deeds for non-judicial foreclosures, hard money, private, and other similar loans are considered a cash transaction in the eyes of the regulation. The hard money lenders, private lenders, seller financing, they do not have an obligation to maintain an anti-money laundering program. And so they're not reporting transactions to FinCEN like an institutional lender. That an institutional lender that has an NMLS ID number or an FDIC number, or if it's a credit union, an NCUA number, if they have one of those identifying numbers, they have an obligation to maintain an anti-money laundering program at their institution. They're already reporting the details on that buyer, if that buyer is an entity or a trust or an individual, whatever their rules might be, pointed at financial institutions. So if you're not sure about your hard money or your private lending, NMLS Consumer Access Online, you can enter the name of that lender and its location, and it'll tell you if it has a number, if it is licensed. That is the nationwide mortgage National Multi-Licensing System, NMLS, National Multi-Licensing System. What transactions are exempt? Well, there are some transactions that are exempt, and those would be anywhere a court is already involved. So if a United States court is already involved, then it's already being overseen. It doesn't have to be reported to FinCEN. That would include the death of an individual.
You're more than welcome to stay in, like you could get in there right there and start warming up.
I'm going to try to mute everybody. Sorry, guys. There we go. All right. So again, where there's a court involved, a death. So if the transfer of property is pursuant to a will or a trust upon someone's death, that's already being seen by a probate court. Divorce or dissolution of a marriage or a civil union. So if the transfer of real property is pursuant to a divorce or dissolution, it's being overseen by the court. Transfer to a bankruptcy estate, a court order, or anything supervised by a court, the result of a grant, transfer, or revocation of an easement, and transfers to individuals. So these would be the types of transfers that would be exempt from reporting. What do we have to report? The real estate reporting form, and I'll go through that with you in just a moment, the different parts of it. It does capture 111 data points. It is the property information, the reporting person's information, the party responsible to report, the buyer's details, the entity and the entity's beneficial owner or anyone in substantial control, the trust, its beneficial owners, and anyone in substantial control, anyone that can move the assets, anyone that can wire funds out of the entity or trust accounts. So substantial control means you can move those assets. Owners with 25% ownership in the entity or more are reported, and those with substantial control. In addition to the details of the buyer and the seller, or of the buyers being entities or trusts, the seller's information is also provided. And the seller's is fairly easy, not as in depth as the buyer, but it is the seller's name, address, residential address. If the seller's an entity, the entity details, its principal place of business address and employer tax ID number, the seller's social security numbers for individuals, and trusts, the trust ID number or FEN number, and the trustee details. One thing that I left out that's in the middle of the page here is all payment and bank draft details, including hard money, lender funds, gift funds, and third money depositors. All money that's received must be reported. The amount, the bank name, and the account number. This is page 1 of the real estate reporting form that was taken from the FinCEN website. This is an interactive dynamic PDF. So it's not something that you would give to your client and they would start to fill in or write on, because these yellow fields are dynamic depending on what you check. If you hit initial report, then the other two will turn gray. So on page 1, the filing name is the reporting person. Typically it's going to be our initial report, but you do have the option to correct previous reports. The date prepared is auto-filled when it's submitted to up to FinCEN. That'll be the date of reporting. You could provide FinCEN a note. I don't know that that would matter for anything. And the legal entity name, so that would be the reporting person. So if WFG is performing your settlement closing, that would be WFG. And when an entity name is filled in, then this yellow first name field grays out because it knows it's not an individual. Address, the property information, the street address of the property being sold, city, state, zip code, and a legal description. Here in this drop down on the live form, it would be lot and block, meets and bounds, and I forget what the third option might be. A legal description must be provided up to 1,000 characters. Then the transferee type, if it's a entity or a trust. And if it's a trust, then this section right here will become yellow and the date of the trust is required, the total purchase price. And then the purchasing entity or trust details are filled in here. The person that's representing the buyer or the transferee will provide their information next. I think there we go. So that could be the representative. You have one representative, but there's 4 beneficial owners and there's 3 people in substantial control. That person is filling this in with all of the details for each person, and they would have to use this plus sign, and this plus sign would add a whole nother section for the next entity or the next person, depending on that hierarchy of entity or trust. The transferor is the seller. The rule refers to the buyer as a transferee and the seller as a transferor because it's not always a purchase. They're not concerned with just purchases. They're concerned with conveyances. This is any conveyance at $0 that is required to be reported if the grantee, transferee, is an entity or a trust. So those accommodation recordings, hey, can you record this for me? If it's an entity or a trust, you can't. You're now bound to collect all this data. The sellers will provide their personal details. Identification, we do not have to provide driver's licenses or passport copies with this rule. It's not like the GTO that's been in effect in King County since like 2016 or 2018. So no copies of IDs, but the social security number for each individual listed and the FEIN number for any entity or trust listed is required. And this is that payment information. So the total consideration is there right here. It's asking, is it hard, private, or other similar loans? And then each transfer. So the earnest money that was delivered, that earnest money would have to be listed here, how it was received. Was it received by a wire or a check? What type of transfer was it? the account number and the financial institution's name, the associated transferee's legal name, and the payer. So if the payer is not the transferee, then who is the payer? Is that gift funds from Uncle Tom? So you've got gift funds from mom and dad, gift funds from aunts and uncles or grandparents. Any funds received must be reported. There are some exemptions for the entities, and a transferee entity, if it is a securities reporting issuer, a governmental authority, a bank, credit union, depository institution, money service business, broker or deal in securities, securities exchange or clearing agency, exchange act, insurance company, state licensed insurance producer, commodity exchange, public utility, financial market utility, and investment company. If the purchasing entity is any one of those types, it's exempt. They do not have to report. Their activities are already being reported and overseen by a governmental agency. Trusts. There are 4 types of trusts that are exempt. A trust that is a securities reporting issuer, a trust in which the trustee is a securities reporting issuer, a statutory trust, defined as any trust created or authorized under the Uniform Statutory Trust Entity Act, or an estate planning trust, where the transfer is for no consideration and the transferor, seller, and or their spouse is also the settlor or grantee of the or grantor of the trust. They're the same people. Those would be exempt. Who must report? The rule specifically spells out a cascade of responsibility, and it lists who is responsible for the reporting. And if there is not that professional person above the next in line, it just drops down. So if we have a transaction and there will be a conveyance of residential real property, and there's a settlement or closing agent involved, the settlement or closing agent is responsible for this reporting. If there isn't a settlement or closing agent, then there's the preparer of the settlement statement. So maybe when in a trustee's deed, in non-judicial foreclosures, there's not a settlement or a closing agent, but the trustee or the beneficiary is preparing a paperwork on a statement of transfer. That's the person that's now required to collect this data and report. If there's not either one of those two, then it falls to the person who records the deed. So there's that accommodation recording walking into your office, or a client asking you to record this deed on their behalf. And now federal law requires data to be collected and reported. If there's not somebody that's recorded a deed, but there's been a title policy issued, then the person or the agent that issued that policy is now required to report. In some states, there are 2 settlement agents. And so then it would be the disperser of the greatest amount of funds. If there isn't any of that, then it's the title examiner. Did you examine that title 6 months earlier? And a deed preparer, if you've been asked to prepare that deed. So this is a cascade of responsibility. It falls to the person in the first position, and if there isn't that person, it falls to the next. If you're not sure who you are, talk to another party in the transaction. If somebody lower in the hierarchy, lower in the cascade, does not, if somebody, let's say number 1, the settlement agent, it might be an escrow only company, and they don't want to collect, they don't want to be involved in this, although the transaction requires it. They could ask somebody else that's involved in the transaction to do the reporting using a designation agreement. So they might ask the title company or the title agent, hey, will you do this data collection? A designation agreement may be prepared, between the two companies. This under the rule, it provides for the designation agreement, and the agreement must include the name and address of the reporting person required to report, and the name and address of the reporting person that they're designating to report on their behalf, the property details, the buyer and seller details, and signature of both of those parties, the reporting persons in the cascade. That designation agreement should be kept for a period of 5 years. And then it would alleviate the person higher in the cascade from reporting. A report is due within 30 days or the date of the last day of the month following closing. So if I close on April 2nd, I don't have to have this reported until May 31st. It's 30 days or the last day of the month following closing, whichever's later. So there's plenty of time to do it afterwards. That is not a practice that we will partake in at WFG. We will be collecting that information up front because we know after closing, parties don't really cooperate, and we may not get all of that information. And the fines are stiff and the penalties are steep. So we don't want to get ourselves into trouble with this law. And with that, I'm going to open it up for some questions. We've got quite a few in the chat. So I'm going to see what we've got here in the chat. And we will share the slide deck after this presentation. Christy will be sending this out to those that registered. And I really hope my sound got better for all of you. I'm so sorry.
It was great. You did a good job.
Thank you. Thank you. Okay, so all or just one criteria need to be met. Well, it's residential property without a loan through an institutional bank or lender, and the buyer is an entity or a trust. So it's those three things. Is it residential? Is there a loan through an institutional bank? And is the buyer entity or trust?
I thought it was if it was an institutional bank, that would be okay. If it's cash or hard money lender.
Right. Yes. I'm sorry. It's the three things that the criteria. Does it apply? Is there it's the question that you're asking, Christine. It's not that you'd have to report. It's if there isn't an institutional lender, it must be reported. If it is an entity or trust, and if it's residential. Crypto, Bitcoin, yes, all the same. Any type of consideration. They're wanting to know what consideration was given. And if it's zero, then we would report zero.
Teresa, if buyer uses their own cash and then they take title in their own names, do you still need to report?
If they take title in their individual names, nope, you don't have to report.
Okay, but if they use their own cash and then they want to take title in their LLC just to protect their privacy, even though their cash is from their personal account, you still need to report, correct?
Yes, because title is being taken as an LLC, and then in the payment information, their details from what account that money comes from will be listed.
I see. So you can still close the transaction in their LLC. It's just their information needs to be disclosed to FinCEN.
Yes, the information on all payments. So if they might have some of our clients have multiple LLCs or multiple businesses, and so they might use money from another one to purchase for this one. we will report the entity that takes title. And then in the payment section, we'll report the details of those payments and the respective accounts they came from.
I see. What if sometimes I have clients where they take title in their personal name, and then maybe 6 months later they want to quit claim deed to a LLC and then they go through probably a real estate attorney to do that. So in that case, I assume that particular attorney has to report it, even though there's no actual money going.
Exactly. Yes. That attorney would have to report if they were asked to put the name of put the property in the name of an LLC or a trust. The only
Do you know why? That doesn't make a ton of sense. If it's for money laundering fraud, if a buyer buys it in their own name with their own cash, and then after closing is putting it into a trust, I'm just not tracking.
Yeah, there's no money.
if they put it into a trust and it's a trust for estate planning purposes. So Megan Carpenter to the Carpenter Family Trust, Megan Carpenter as trustee of the Megan Family Trust, that is from you to you as trustee, and that's an exempt transfer for estate planning purposes. If it's from John and Megan Carpenter to John and Megan Carpenter, trustees of the Carpenter Trust, that is husband and wife to husband and wife, or brother and sister to brother, same names, no changes. Estate planning purposes, those are exempt trust transfers.
What if the trust name is not the names, but it is still just Megan and John?
Like, I don't know, like I know, Three Dogs Trust.
Yeah, exactly. And the trustees are Megan and John.
Now, I'm not sure if for estate planning purposes, they would name their trust Three Dogs Trust. So I can't answer that question for you right now. I don't know if there's a particular state rule. But Megan, we can get that answer and get it back to you.
Okay.
Teresa, so for the LLC, along the same line, I've had a lot of clients, they create an LLC because it's a rental property, so to shield their name from potential tenants. And then within this LLC, they themselves are the only members. Like, the property may be in Mei Yang's name, and then in the LLC, Mei Yang is one and only member with signature authority. So it's essentially the same thing. But because it's LLC, it just has to be reported regardless of membership information, correct?
Correct.
I see. Thank you.
Yeah,
You're
the rule's kind of crazy, but we just have to follow it, right? And so is there a cost to file this information per transaction?
Christine, there is, FinCEN does not charge through the BSA e-filing. Escrow companies, title companies are all filing rates for this added requirement. So check with your local rep as to what rate would be charged in your area.
And then if let's say, because I know last year all the LLCs or any company had to be registered with FinCEN. Everybody got a FinCEN number because we had like 80 LLCs I registered last year.
Right.
And then now that's not a requirement because of the case law. But then some of the members of the LLC have their own FinCEN identification number. So is that beneficial to provide to the escrow people to say, hey, so-and-so already has a FinCEN ID number? Is that beneficial in any way?
Nope. Doesn't matter.
It's just peachy.
Isn't it great? That's all that information. Yeah. No central repository.
Because it has the social security numbers, the ID, where they live, all that minutia, because trust me, I had to do it for.
Yeah. So while you know, the beneficial ownership information was required to be reported under the Corporate Transparency Act. And then there was a stay placed upon it, and they did not enforce the beneficial owner filing for those entities that were already established. Although now newly set up LLCs or corporations must report that beneficial ownership information. So they're not enforcing that. And no, FinCEN numbers were issued. And I believe on the data collection form, there is a place for your FinCEN number, but it's really not doing much of anything, doesn't alleviate any
reporting for
doesn't
you
do
guys.
anything
You
for
know,
us.
we could provide you with, say, hey, this is our.
No,
Well, that's
unfortunately, we're
unfortunate.
just asking for all of it again. Now, some of the companies, I know that a platform that WFG has selected to use for this data collection, it will maintain the consumer's information. So if we're working with a builder or an investor that's a repeat customer, and we're having to ask you every single time, yes, this is for every single lot. One deed equals one report. So if there's a deed involved and it qualifies, then there's a report. And that seller, that builder, that investor that's rolling over several of these monthly, the system will maintain their information. They'll be able to, it'll repopulate all the fields with that which has been saved from a prior report. So that's nice. That's if you're closing with WFG, our data collection system will save you time on your subsequent transactions.
So this will be an additional fee in excess of the escrow fee and the title insurance premium and the recording fee and the foreclosure fee and the
Everything you want to add on top?
Yeah, let's
Christine,
just keep on going.
keep on going. The FinCEN rule actually spelled out in its 130-page document that it anticipates that the data collection and the work involved with this was like 3 to 5 hours. They estimated that, and Alta estimated that $750 was not enough per transaction, because on average, some are going to really be pulling teeth. The ones that are smooth or make up for it, but there's going to be a lot of time involved in this. There's a lot of training that everybody's required to, hours and hours that I've delivered training over the last 8 months. Let's see what other questions might be in the box.
Hey, Teresa, you mentioned
Yes.
about flips. Now, what does that mean? I mean, flips is when you buy something on an auction, it is you have to pay cash mostly, or you get a very short-term loan.
Yes.
So
these auction properties are going to be interesting because we're working with the trustees. If some of these properties at auction did not go through a judicial foreclosure through the courts, the auction company or the trustees are having to do this data collection now.
Okay.
If a flip, if somebody has a contract and they assign the contract, and so A to B, and then B's coming up with the money and buying the property, but B's going to pay a $10,000 finder fee. I don't report A, I report B, the entity that actually takes title on the deed.
Okay.
So if a contract's assigned, I don't report that initial name. It's who takes title to the land is reported.
Okay. Thanks.
So clarification question on that same exact topic. Basically, anyone can pay without being disclosed, but whoever takes title is who has to disclose. Does that sound right?
Well, everybody that pays is also being disclosed.
Okay.
In the payment section, the name of the account holder, the account number, and the bank where that money sits is reported.
Okay, so any middlemen who are not paying and are not taking title, they don't need to report anything. It's
Um,
anyone who's only involved with giving money and who's taking title.
right.
Okay,
Who's taking title and who's sending money to closing?
okay.
So Teresa, so if I if I lend money to my kids and they are not getting a loan from the third party, is that uh, how? So my information will have to be
Private
provided.
financing. Yep, private financing, your account information and number would be provided because you provided the money.
Okay, sounds good.
But your kids, if they take title as individuals, they're not getting reported,
Oh,
right? So if your kids had take title as an LLC or a trust, it's reported.
correct.
Remember,
But
it's who's taking title.
if they if the two kids take title in their individual names, in other words, the individual names are on the title,
Yep.
and then they convert it into an LLC down the road. Is that so? At what point?
That would be a $0 transfer. It would be from kids to Kids LLC. There's
Yeah,
no settlement company involved. They just had an LPO or an attorney prepare that deed.
correct.
That's who's required to report. But there's no money at that point in time being reported.
Okay, got it. Thanks.
Mm-hmm.
Teresa, does WFG have some sort of information sheet? Perhaps we can kind of share with our real estate clients. I'm a real estate broker. So it sounds so, so people know upfront what information is being reported to FinCEN so they can plan their purchase or sale accordingly. Is there?
Absolutely. We have some flyers, some FinCEN flyers. And Christy has those. I can make sure that along with this slide deck that our flyers, our informational flyers are also provided.
That'll be
Like Teresa
that'll be
said,
great.
we've got one towards the real estate agent, so it simplifies it for you. So if this seems like a lot of questions and a lot of details, we'll send you the agent version and we'll also send you the version that makes sense for your clients.
That'll be awesome. Thank you so much, guys.
You're welcome.
Welcome. There's a lot packed in this rule. Let me just check the chats one more time and see if we've got any questions in here.
While
Yeah,
you
there's
are
a really good one about if a broker credits. That's a great question.
As a broker, if I credit a portion of my commission to the buyer, am I reported since I'm gifting the funds to the buyer? That's actually not monies coming in. That's a debit credit on the settlement statement. So I don't see that as monies received. So no, that's not a deposit that we're making. Good question. Does the real estate broker have any responsibility in the cascade of responsibility? No, they do not. This is just for your awareness. All of this information, if you're a real estate broker, this is to make you aware because we are digging deep. We're going to have to ask those buyers and sellers for this information. And we just want you to be aware of it. Some states are actually adding this to their sales contract. So your real estate association, your local real estate and state real estate association, check with them and see if there's any changes being made or if there's a new contract available.
how long should we, as a real estate broker, don't I have the partly responsibility to you as an escrow agent to make sure that the information is properly collected and in time so the closing can be done on time?
Yes.
Is there a timeline that we should allow after the mutual is done and after, you know, the lender is identified and the source of funds and stuff like that is identified in the first, assuming in the first 10 days after the mutual. Uh, Sometimes, the transaction, if it's a cash transaction, it, you know,
Goes
the
fast.
closing goes very fast. How
Mhm.
much time should we allow? So as an agent, I am on the top of it to make sure, because sometimes when there is cash involved, um, it's very difficult as a real estate broker to ask for all those details from the buyer.
Right. It
And
is.
yeah, so in that case, how do we, you know,
So this is a federal law. This is a federal law that because the buyer has chosen to take title as an entity or as a trust, federal law requires the data be collected and reported. And the California contract, for an example, says 7 days. Buyer and seller have 7 days to provide this data collection.
oh, okay,
Okay, that's just an example for you.
right.
Our system, once we have at WFG, once escrow has the contact information for buyer and seller, and that includes the email address, their profiles will be created in the data collection platform, and they will receive an email invite to enter their data. This is a secure data collection website that will push a button and it'll go directly to the federal government. And this is that private secure information that's going to the federal government that's not on a public database.
I
That
see.
platform, once their order and profiles created, an email will go to the buyer and to the seller every 3 days until they complete.
So is that 7 working days or seven calendar days?
I believe it's 7 calendar days according to the California contract.
Okay. Okay. So
And
So is there on any of the transaction forms, is there any kind of place that you would recommend that uh, the seller requires that the uh, buyer has to provide such an information, or the buyer may show a complete surprise after the mutual and drag their feet?
yeah. So if you're representing the seller and you're presented with a contract and the buyer happens to be an entity or a trust, you might want to, as the seller's representative, right? An addendum, buyer and seller agree to provide FinCEN data within 7 days.
Okay.
You might want to write that in if it's not part of the standard contract.
Currently, it is not part of the standard contract,
Right.
correct?
Correct.
Okay.
I haven't seen a change to Washington yet.
Okay. But you have seen it in California?
Yes.
Okay.
Sorry, we had the question come into our office. What was that again about? So you've seen what in the California contract already?
They've added the FinCEN requirement, buyer and seller must comply with data collection within 7 days. There is a question about the price and fees. Those fees are not split between buyer and seller. Depending on the area and the state, I have seen most all of the fee go to the buyer, because it's not the seller's fault that the buyer decided to take title as an entity or a trust. All right, Christy, I don't think we have any more questions.
I was just gonna bring up to the Northwest MLS. As a title company, we don't have access to the Northwest MLS, but when we did check in here locally, what we heard from the Northwest MLS is that they included FinCEN in our forms revision that will be published on the 24th. There'll be a new disclosure on purchase and sale agreements. We reached out to a contact of escrow trade groups and got information. So just know there's more coming from the Northwest MLS. We don't get that information as a title company, but do pay attention on that on the announcement on the 24th.
Thanks, Christy. That's perfect.
I had one other question.
Sure, Megan.
Towards the beginning, you had a slide that had a list of exempt files that fall under the 3 categories, but are still exempt, like if it's a death or a divorce. And is that because they were already filling out this same thing?
A death or a divorce, because when court's involved in a divorce, the divorce decree will say John will deed the property to Mary, or Mary will deed it to John after, the sale and refinance, the dissolution dictates. When a will or a probate is filed for a deceased, it might say that, upon death, the property is transferred to blah, blah, blah. And so those type of conveyances are exempt.
Got it.
So does that also include the trust when the trust is the trustee and the names are not the same upon the death of the parents, for example?
Upon the death of the parents?
Yeah, so the parents have the property in a trust, they pass away, and it goes to one of the trustees, and that person puts it into their trust. Is that exempt? Because the names aren't the same.
That's a brand new, that the names aren't the same. That's a new trust, Gail. And so that's a conveyance that would be reported.
Christy, you mentioned that you reached out
to
the NWMLS. Did you reach out to SEBA as well? Are they updating their forms?
I have not.
Okay.
I have a doozy of a question. And if this actually did happen, and I'm wondering now if it happens from here on out, how I would have to advise my seller and or buyer, whichever side I'm representing. Follow me for a minute. In this example, and the ultimate question is going to be, do we have to reach out to all of the previous sellers and buyers in LLC form? Here's what happened. I represented a seller, and a buyer wanted to use their collateral, their own property somewhere else as collateral property. In the context, let's say it's under an LLC, but the property wasn't reconveyed properly when they purchased it in the past. And so then the hard money lender is holding up cash because they need that property to be reconveyed to use it as collateral to purchase now my seller's property. So let's say that we have to go through all this process. For whatever reason, something wasn't reported when cash was changed or wasn't reconveyed properly. And now that it is being reconveyed, what advice would I have to give to my seller? Would I have to say, this is going to take some time, we have to reach out to these people to have them report, or what does that look like at that point with these new rules?
We're not, if it's a corrective instrument, you don't have to report.
Okay, so it's still,
if you're correcting a legal description or correcting a name or something, the conveyance document and the deed of trust documents already on record. Now something's having to be recorded to correct those documents already on record. Those are exempt. The corrective documents.
Okay, so we would still be able to close as normal. I mean, in that kind of a situation anyway.
If it's a new instrument, not correcting a previously recorded, if it's a new conveyance, that would be recorded. But if your conveyance was already on record and you're correcting something in that conveyance previously recorded, Stephen. And I'd really have to pick it apart because there could be so many if this, then that's.
Yeah. It wasn't reconveyed. It was done through a different. We closed our seller's property through WFG, thank God, because Tiffany Olson was fantastic and handled the situation very well. But the collateralized property from the other buyer, who I never knew or represented, closed through a competing company. I'll just leave their name out of it. And they were instructed to not reconvey that property, and so that property was never even reconveyed. For whatever reason, I don't know why, but that's what happened. And so it sounds like since it wasn't reconveyed, now that it has to be reconveyed, I think that's where my disconnect still gets lost. Does that make any sense?
And then I've got to ask you, when you say reconveyed, are they reconveying a deed of trust?
Yeah.
See, I have to look at your transaction details because now I've got a little confusion going on.
Okay.
I have
I
to
can
look at the
also
commitment, the requirements.
okay. I
Chris,
can also
Chris,
just
you know,
check in with Tiffany, since she knows all the ins and outs about it all anyway. I can also just check in with
okay.
her and ask
And
her.
she can reach me if she has any questions. Just tell her to reach out to Teresa to really pick this one apart if she's got questions.
All right. Thank you.
Yeah,
Yeah,
you bet.
the law states that a reconveyance needs to be filed within 60 days of receipt of payoff, correct? That's still the rule?
That's, yeah, 60 days for reconveyances. But this rule doesn't apply to reconveyances.
Right,
This is
right.
just,
Yeah,
so
we're
to make
not
sure we're on the
dealing
right
Yeah,
terminology.
that's not, it's totally different, but yeah, deed of
All right.
reconveyance is saying you've been paid in full. That's got nothing to do with, the purchase.
Well, I want to thank everybody for joining today. And Christy will follow up with materials after this. And thank you for using WFG. And I wish you a nice afternoon and best of luck with this new rule. We're here to help you.
Thanks, you guys.
Thank you.